Greetings, 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 greetings. It is I, King Clifford Jefferson, a Senator Godfrey, the fifth Count of Anjou, the son of Folk, the ruler of Jerusalem. I'm the reincarnation of King Edgar, the peaceful, which we know here at the Third Temple English Church of England as the Vicar of Christ or Melchizedek, the King of Righteousness. It is October 9th, 2024, which is equivalent to the Berber year 2974. I greet you in the name of our predecessors. I greet you in the name of our successors, which were all included as ancestors on behalf of our predecessors in lieu of our successors. I greet you in the name of my Queen, Sister Galveston from the House of Galveston. I greet you in the name of Archbishop Belmont from the House of Belmont. I greet you in the name of all those who have traced themselves back to their forefather, to their divine lineage, do what we call hereditary right. Okay, so today we'll be discussing that, but the topic and the title to this particular lecture would be called or styled as New Jersey Freeholders Stole Our Land, the Land of the Plantagenet. The New Jersey Freeholders have stolen our land, the land of the Plantagenet Kings. Okay, once again, New Jersey Freeholders have stolen our land, the land of the Plantagenet Kings. I will prove that beyond a shadow of a doubt today. Okay, and when I say the land has been stolen, it's been stolen from us, the Anglo-Saxon Berber of darker complexion. Okay, so please pay very close attention to what's being said today, because your relationship to the inheritance that was promised from you from time immemorial can come to fulfillment. Okay? So you must pay attention. Now, where do I want to start? Let's start here. A lesson in your inheritance. This is what this class is all about. A lesson in your inheritance and how your inheritance relate to you, your family, and your surname. Okay? To you, your family, and your surname. I don't know how simpler to make this, but nonetheless, I'm obligated because right now you have made your choice. You have made your choice. You have committed an act of abjuration. Okay? You have committed an act of abjuration. I don't know how many of you know what that means, but we will be talking about it today.
Administrator Plantagenet as well, the director of the National Hurricane Center, Mike Brennan, director of the National Weather Service, Ken, Secretary of Homeland Security, Alan York, and
Bear with me.
Coast Guard, Admiral Linda Fagan. We'll be briefing with Administrator Criswell. Over to you. Thank you, Lynn, Mr. President, Madam Vice President, and sponsors. Farm. Milton is Horse Farm and will remain a hurricane as it crosses over Florida.
Nope, that's not what I'm looking for. Bear with me, y'all. Okay. All right. So let's get started. Okay, as you can see here, you have New Jersey real estate book, the essentials on New Jersey real estate book. Apologize. Hold on, let me go back. So everything you see here is going to be everything we talk about is going to come right from this book. Okay. Everything we talk about this morning is going to come this afternoon, I should say, going to come right from this book. So listen very close. All right. Everybody take a good look at that. So it ain't like I'm just talking. I'm actually showing you. So you have no excuse. All right, especially when it comes to your inheritance. Okay. This is this is called a chapter 6 on estates and interest. Okay. Estates and interest. All the highlighted parts, that's my work. Okay. I went through this book like a fine tooth comb. Okay. We talk about estates and interest. Okay. Let's look what they refer to as estates and interest in this book concerning estates and land. Okay. Very important. Page 74. Estates and land. Not all forms of ownership of real estate are equal. A owner may or may not be able to pass property on to heirs. Sometimes ownership may exist only as long as property is used for a specific purpose. In addition, other persons may possess certain interests, legal claims, or rights in one's real estate. The amount and kind of ownership interest that a person has in real estate is called an estate and land. Okay? It's called an estate and land. Freehold estates are estates of, of indefinite length. A person may own an estate for what was it? A person may own the estate, but not forever. The freehold estates are recognized in New Jersey. They are the three freehold estates that are recognized in New Jersey are being simple, being determinable, and life estates. Okay. Those are the only three types of estates are recognized in New Jersey, and there's the only three types of estates that are recognized in the United States. Okay? We must understand that. The one we're going to concentrate is fee simple. Fee simple estates is an estate in fee simple and is the highest type of interest in real estate recognized by law. A fee simple estate is one in which the holder is entitled to all rights in the property. There is no time limit on the fee simple estate. It is said to run forever for the life of that individual. On the owner's death, the estate passes to his or her heirs. The term fee simple, fee, or fee simple absolute are used interchangeably. Okay? They are used interchangeably. Okay? All those are subject to the remandament rights of the grantor. Okay? They are subject to the remandament rights of the grantor. You should be writing these terms down, everyone. You should be writing these terms down. Write these terms down, everyone. Chapter 20, transfer of title. Okay? Chapter 20, transfer of a title. Well, everybody should be here. I don't know why nobody's here, but all good. Transfer of title. Title to real estate means the right to or ownership of land. A parcel of real estate may be transferred. Greetings, welcome. Welcome. Gavin D. Different. Welcome. The title to real estate means the right to ownership of land. Once again, title to real estate here in New Jersey, and we know there's only three types of ownership: fee simple, life estate, and free indeterminable. Okay? The highest form is fee simple. So title to real estate means the right or ownership of the land. A parcel of real estate may be transferred from one owner to another by the living or it may be transferred by will or descent after the person has died. In every instance, however, alienation, the transfer of title to parcel of real estate, is a complex legal procedure involving a number of laws and documents. Once again, we're dealing with alienation of property. Okay? alienation of property. And the only way you can have the ability to alienate property is have some type of interest in the property, and that's by way of some type of deed. Because the deed is nothing more than an instrument of a right to convey. The word property means the right to transfer. The instrument that you have shows that right to transfer in lieu of what we call the right of conveyance. Let's move down. The topic today we're going to discuss is called Queen Imperatoris. It's dealing with the King's, His Majesty's law on buyers purchasing land that don't belong to them. All right? Queen Imperatoris, which was the act passed in 1290 by King Edward I. Okay? We must understand that. Alienation of title falls on two categories, voluntary and involuntary. Once again, voluntary and involuntary. Once again, alienation of title, which is the right to convey land, can be conveyed by two ways, voluntarily or involuntarily. So we should discuss the two ways. Write these words down, voluntarily. Voluntarily alienation transfer of title may be made by a gift, sale, or an exchange. Okay? A gift, sale, or an exchange. To transfer title by voluntary alienation during his or her lifetime, an owner must use some form of deed or a conveyance. So a deed is nothing more than an instrument showing the right to convey property. It does not, in fact, mean that you own the property. Title to land may be transferred voluntarily between an individual and the government through dedication or a public grant. A developer passes ownership of a subdivision of land earmarked for streets and roads to a municipality through the process of dedication. Land owned by the government be transferred to individuals through a public grant. This is called on the federal level transferring public land that's part of the public trust. So you granting public land that's actually originally a part of a public trust, or what we call the public domain. Okay, we must understand, and that's dealing with voluntary alienation by way of a gift, a grant. Okay, just giving it away. Then we have involuntary alienation. Title to property can be transferred by involuntary alienation, that is, without the owner's consent. Such transfers are usually carried out by operation of law, ranging from government condemnation of lands for public use to the sale of property for tax delinquent for property to dealing with some encumbrance, dealing with some delinquent tax or mortgage lien. When a person dies interstate and leaves no heirs, the title to his or her estate passes to the state by what we call escheat. Okay? When it passes to the state, any state for that matter, is by escheat, and the only way that can be done is by way of what we call interstate, meaning that there are no heirs. It becomes abandoned property. Okay? So there's two forms of conveying property by way of a deed. All right? It's by voluntary and involuntary. Okay? We must comprehend that. Let's show a diagram of that. Make this easy for you all to understand it. This is the power of the state over involuntary alienation in regards to intel property. That's what we call interstate. You got two types, intel and fee simple. And we know, as the book said, the highest form of ownership, or the highest, is fee simple in the United States as well as in the state of New Jersey. The other form is called intel estate. And intel estates is left for heirs, but when there are no more heirs, it automatically becomes interstate, meaning that person died without leaving a will for the beneficiary. All right? For the beneficiary. You see a diagram of the operation of the law and the process of involuntary alienation. This is also called acquisition of sovereignty through the eminent domain power that the state has and that the federal government has. They have eminent domain power, which is called compulsory purchase power or acquisition of purchase power. Okay, this is nothing more than what we call prescription at law by way of prescription of sovereignty. I'm going to say it again. Prescription of law by way of prescription of sovereignty. Somebody claiming to be the sovereign. Okay? Somebody is claiming to be the sovereign by way of what we call the laws of discovery or the laws of conquest. We all familiar with those terms, right? Okay. The first box you see is when the heirs die. When the heirs die, that means that there are no more heirs in the land, in the property, and everything that's movable and non-movable, which means intellectual property, which can be tangible and non-tangible, automatically becomes interstate. Now, if it's just left there, then whoever discovers it takes it. If no one discovers it, then I mean it reverts back to the superior government, which is what we call the government. And this is a form of the process we call escheat power. Escheat power. And escheat power is for the state to take the property is because it's abandoned. All right? When it's abandoned, the state takes it and then it automatically falls and taken for public use. Okay? Taken for public use. And the only way that can be done is through the eminent domain power of the state. Okay? The eminent domain power in the state. That's the second row, the box in the middle. All right? As a result of that, it becomes subject to the authority of those who have a license to convey land, which usually results in a broker in real estate, which is licensed by the state, okay, through their public government and their public agencies, okay? And as a result of the encumbrances created by the state, known as taxes, we call that feudal taxes or feudal, which means a fee, okay? And you can pay your mortgage and everything else, but if you don't pay the tax on the land, it automatically is subject to the eminent domain of the power for failure to pay your taxes. Okay? Therefore, you fall into the process of what we call foreclosure, which then it falls under what we call subject to being auctioned off by the state because the state allowed the broker, i.e., the real estate agent, to convey the land in the first place by way of being called a stakeholder. You got a shareholder and you got a stakeholder. I don't expect you to know those terms, but you need to write them down and review them. Okay? All this is a process of what we call adverse possession. Open and notorious, continuous, hostile, adverse use of another property for a prescriptive period. As I said, it's called prescription of law. Through what we call an encumbrance, what it's called? It's called easement. An easement is a right to use property that don't lawfully and legally belong to you. Okay? I can't say this more simpler. All right? This is coming straight from the book. They have involuntarily alienated the land from the people because the people assume not to be there. And when we deal with law in regards to the land here in America, we're talking about the English people. Okay? We're talking about the English people. Okay? So who are the English people? All right? In this present day. Because according to the statistics on the population census, there are no English people, but there are people here with English surnames. Okay? And a surname is an hereditary name based upon certain qualifications of peerage. Okay? And that breaks down to what we call the royal family, the nobles, the peasants, foreigners, etc. So your surname tells it all. Okay? This is what we will be talking about again today. All right? So once again, the highest form of ownership, according to New Jersey real estate, and I'm pretty sure in every other state, is fee simple. Okay? Fee simple. Write that term down. If you are an heir, then you should not be receiving a fee simple estate. Your estate should be entail. We'll be discussing those two terms today. Okay. So with that, let's move forward. Newcomer Gavin the Different, are you comprehending so far? Please respond in the chat. If you're still there. All right, that's good. I'm gonna go real slow for you. Now, we're here at the Third Temple English Church of England, which is a body of politics, okay? This is a polity, not in the sense of politics, but a body of politics, i.e., governmental structure that's composed of a fusion of three governments: the executive, the legislative, and the judicial, which I'm going to show you here today, okay? All authority that resides in regards to the protection of your state, which we call crown land, is footed here in what we call New Jersey. Now, let me show you the people who stole the land from you. Okay, these are the ones who have stolen the land from us. Let's get a picture of them, a view of them, real quick. Here in New Jersey, I don't know who they look like in other states and their counties. I'm talking about here in New Jersey. Mrs. Gavin the Different. If you got any podcasts out there that you know that would like this information shown, please get in touch with my Archbishop by leaving it in the comment, and we'll definitely are welcome to join your platform, or you welcome to our platform to discuss these matters, because it's definitely of a public importance. Okay, so this is the website for Middlesex County Board of County Commissioners. Okay, the Board of County Commissioners were previously known as what we call the freeholders. Okay, simply because they have an interest in the state and land, which we call freehold. Okay, it's called freehold. We must understand that. Now called the Board of County Commissioners. The county commissions is a term used by all 21 of New Jersey counties to describe county legislators. So the county commissioners are called the county legislators. We know legislators are the ones who make the laws. Okay? This is the head director of the Board of County Commissioners, Ronald J. Regis. Here are some other county commissioners: Shantae Nara, Clarabelle A. Ascona Barbara, Charles Kane, Leslie Capel, Chanel Scott McCullum, and Charles E. Tamaro. These will all fall under what they call board commissioners on a board who deals with the creating legislation. And we know creating legislation is dealing with making or enacting laws. Okay? We must comprehend that. All right. Who are some other people who are relevant in this matter? Let's see. Constitutional officers. Because these are thieves, crooks. I'm going to prove it. Everybody hold that thought. Sorry, I got to warm my coffee up again. Here you have constitutional officer Nancy J. Pinkin, the county clerk, the one who records all the deeds for all those who create those instruments for conveyance, title to real property, as we read in the so-called Essentials of Real Estate book. We also have the sheriffs who are responsible for overseeing the foreclosure process, as well as the sheriff's sale for non-payment of a federal tax that they imposed upon you, okay, on the land. Then you have Clarabelle Cortez, These are all your constitutional officers, hence the word constitutional officers. So they take an oath on behalf of the sovereign citizens to protect the sovereign citizens. But who are the sovereign citizens that they're sworn to protect? These are called the people. But what people? Because the people that we're talking about in regards to the status of their people are not relative to any type of inheritance or inherency, dealing with an inheritance left from some predecessor. It has to do with your new oath of allegiance to your newfound citizenship, which has to do with you being a naturalized foreigner, because you were not the original subject or citizen of that municipal law, which is called the common law of that state. Before it became a state, it was called a colony, and the laws governing the colonies prior to the colonies becoming colonies was called the common law of England, overseen by the British, which were Scottish monarchs, going from King James the First to Queen Anne. Okay, we must comprehend that. You follow that, Miss Gavin D. Different? Do you comprehend that? Wait for your comment. All right. Now, this is a case that's filed presently in the Superior Court of New Jersey, okay, which is actually the King's Court, as quoted by Billen versus Harris, which conveyed and transferred all the power of the King's bench to the Superior Court of New Jersey. Okay, very important. This is the docket number, MID, Middlesex County Law Division, the reference number, the date it was filed, and the number of documents filed with the actual filing. Okay, and as you can see, this is a filing of anti-corruption application filed with the Attorney General for the state of New Jersey, who oversees complaints filed against the state. Okay, filed by King Clifford Jefferson. All right, that's me right there. That's my address, the territory which we reside. Detailed description of the incident in regards to me filing an anti-corruption, not with the court. This was just filed with the court as a what we call a submission to support my actual complaint filed on September 16th with the docket number I just referenced. The complaint was served upon the state of New Jersey by the Sheriff's Department September 19th, 2024. Summons was received by New Jersey Superior Court on October 1st, 2024. The complaint states that the state of New Jersey has taken the Crown property, and as the Crown representative, a complaint has been filed for the relinquishment of all real property here on allodial land. I'm going to prove everything that I'm saying here today, but guarantee different. So it says that real property here on allodial land. New Jersey Revised Statute 46:1-2-3-1-5-6-10-15, as well as 7-5, confirms that feudal relief is warranted in this matter. A criminal case was filed maliciously against His Majesty in his own courts. The person that it was sent to was Matthew J. Plankin, because it was uploaded to the actual prosecutor's office dealing with anti-corruption complaints. They're known as what we call whistleblowers, okay? So that was filed with the court, all right? By clicking this button, it served as my signature. Also, there was a previous corruption complaint filed against them as well, which you see here. All right? This was also submitted to show him that the Attorney General had no intentions of actually reviewing the corruption complaint filed against the state of New Jersey in lieu of the complaint that I filed. Okay, so here you see King Clifford Jefferson dated 7/21/2024. The new one was filed October 2024. Okay, this is to get the Attorney General moving. Okay, let them know you in some trouble. Okay, and this is also actual copy of the actual docket so that you can see. Let me get my coffee. Hold that thought. Okay. Number, you see the same docket number. You see the caption. Okay. Now, you show me somebody acting as a liberator, a king, doing something for his people on this level. All right. There you see the docket number. You see the caption number. Jefferson King Clifford Jefferson versus State of New Jersey. Civil parts, case type, real property. You see that? Real property. Very important you understand that. This is the case regards to real property that New Jersey stole from you, i.e. heirs, English, Anglo-Saxon, Berbers, and all those who were subject to the king's liege, all right, who took an oath of allegiance to the king to be protected by the king on the king's land called Crown Land. All right. To not do so, especially if you're on air, it's what we call an act of abjuration. So you denounce your citizenship, which is what we call treason. As you can see, party description, you see complaint with jury filed by who? King Clifford Jefferson. Once the tracking number was assigned, I filed an amended complaint to update it, and the summons complaint was submitted, as well as it was served by the sheriff's department, and then the jail correspondence that you see we just reviewed a second ago, based upon the anti-corruption complaint, was also uploaded to show that the docket is presently showing there's a combination of the uploaded submission as well as the original complaint or the amended complaint filed against the state of New Jersey in regards to receiving property unlawfully. Okay, I ain't got time to go through the statistics of it. You know what I'm saying? You have to reveal other lessons for that. But for the sake of time, let's continue on with the lesson. Do you understand so far? Gavin's the different? Are you comprehending? I'm gonna wait for you. Okay. Only reason why I repeat, do you follow, because I don't like going where people don't understand. It's for naught then. Okay. So back to the constitutional officer, the one who responsible for filing instruments of conveying deeds is the county clerk office, which is the constitutional officer, which name is Nancy J. Pinkins. Okay. You got a picture of her. All right. Now, why is this important in regards to the complaint that I filed? Because I went down to take the land back, which was stolen by the county clerk. And we know the clerks record property on regards to those who claim to have an interest in the property legally, but not equitable, not an equitable interest, but a legal interest in the property, and which is why we're going to be talking about this today. Now, who is this Nancy J. Pinkins, the county clerk office? All right. Why is she important? Because if you go to our certificate of incorporation, which is also known as our charter, as you can see, she's right up here on the county clerk's what we call cover sheet. She see her name, Nancy J. Pinkins, Middlesex County Clerk Office, recording data cover sheet page pursuant to New Jersey Revised Statute, Title 46, colon 26A-5. Very important for you to understand that. There will go our booking page number, all right, and all the pages in regards to the filing, okay? Recorded by this constitutional officer, so they know who we are, okay? And when we record it as a religious society, we record it as a corporation sole. Under New Jersey Revised Statute 61-28, which says right state under the charge of Great Britain, safe from repeal, an act to incorporate trustees of religious society for property held in corporations and place thereof. Once again, I repeat, 61-28 says right state under the charge of Great Britain, save from repeal, an act to incorporate trustees of religious society for property held in corporations in place thereof. So that means that corporations are holding property that actually belongs to the religious society. Okay? Very important. What religious society does the property belong to? Is this society. The Third Tip English Church of England. Our certificate of incorporation, i.e., our charter, is the Third Tip English Church of England, the king, his heirs, and successors. That language is very important in the conveyance of some type of an estate. Okay? You find it. It didn't say heirs and assignees. It says heirs and king, heirs, and successors. That means heirs of the blood. Okay? The undersigned, each with the capacity to contract, hereby execute and acknowledge the certificate of incorporation for the purpose of forming the religious nonprofit in accordance with New Title 16, colon 1-1-1-2, as prescribed by 61-28, which I just stated for the record, pursuant to 16-1-4, which is the powers that were also incorporated based upon our certificate of incorporation. What is the aim and objective of our religious society? Article 2. The business type, this is a corporation sole of a royal peculiar, the crown. A corporation sole is a legal entity consisting of a single sole incorporated office occupied by a single sole natural person. This structure allows corporations, often religious corporations or commonwealth governments, to pass without interruption from one office holder to the next, giving positions legal continuity with the subsequent office holders having identical powers and possessions to their predecessors. Okay? What is the purpose of our business? A means for an ordinary transfer of the ecclesiastical property serving to keep the title within the denomination of our religious society. In order to keep the in order to keep the religious property from being treated as an estate of the vicar of the church. The property was titled to the office of the corporation sole. A corporation sole, the crown, is a legal embodiment of the executive, legislative, and judicial governance in the monarchy of each commonwealth rim. These monarchies are united by the personal union of their monarch, but they are independent states. The concept of the crown developed first in England as the separation of the literal crown and property of the kingdom for the purpose and personal property of the monarch. Article 4. The Magna Carta Clause 1 states that the liberties of the English Church, we form now the Third Typical English Church of England, first, that we have granted to God, and by this present charter, have confirmed for us and our heirs in perpetuity, that the English church shall be free and shall have its rights undiminished and its liberties unimpaired. As English king, heirs, and successors, duties and allegiance to restore the peerage, life, and history of the English Anglo-Saxon Berbers, the English church, our customs, laws, traditions, religious belief, back to time immemorial here in America, and commemorate our saints, martyrs of the past kings and queens, restore the mysteries of King Edgar the Peaceful, known as Jesus Christ, which I'm the reincarnation of in this present day in time. Okay? And one more I'm going to show you. New Jersey Revised Statute 46, colon 7-5. New Jersey Revised Statute 46, colon 7-5. Conveyance to religious society prior to incorporation, valid after incorporation. Where any conveyance of real estate has been made, executed, and recorded in favor of any religious society, association, or corporation of the state, as the grantee therein, and such religious society, corporation, or association has failed to record and file the proper certificate of incorporation in the manner prescribed by Title 16, Corporation, Association, and Religious, or by any law enforced at the time when any such society, corporation, or association was incorporated or attempted to be incorporated until after the making and execution of such conveyance and the recording thereof. And any or all such conveyance shall be valid and effectual in the law as if made, executed, and delivered to such religious society, association, or corporation after the filing and recording of the proper certificate of incorporation as if it was made to such religious society, association, or corporation during the period of its incorporate existence. And the record of any such conveyance so made to any such religious society, religious society, religious society, association, or corporation prior to the recording and the filing of a certificate of incorporation as aforesaid shall be of the same force and effect as if the conveyance had been made, executed, and recorded subsequent to the recording and filing of such certificate of incorporation, and should be admissible in evidence as fully and completely for all purposes as if such conveyance had been made and recorded during the corporate existence of such society, association, or corporation. So that means that when we incorporated in the state in regards to the original corporation that existed prior to our knowledge, that means all the rights that they had when those corporations, i.e., religious corporations, existed, we now have the same incorporated right, which means that the rights that we have are perpetual. Okay? And of course, I want to show you one more. (16:1-43.9). Powers of consolidated corporations. The consolidated corporations shall have and may exercise all powers conferred by the respective certificates of incorporation or charters of the constituent corporation. By Title 14, we're not doing it under Title 14. We're doing it under Title 16 because we're not a corporation dealing with commerce or trade. Very important that people understand that. And it says that under Title 16, and in particular, the powers conferred by Article 5 of Chapter 1 of Title 16 of the revised statute, so far as the same are not, I repeat, as so far as the same are not inconsistent with this act and are necessary or convenient to be to the furtherance of its object and are in accordance with the doctrine, government, I repeat, the doctrine and government, discipline, and usage of the church or religious denomination to the jurisdiction on which the constituent corporation were subject. It shall have, and among other powers, the powers to invest, change the investment of and reinvest its endowments in funds and such an investment whether or not prescribed by statute in such manner as it is deemed proper. Do you understand that? Gavin D. Different. Wait for your response. Make sure you're still there. All right. Let's go back to the constitutional officers. Okay? Let's go back there. These constitutional officers got their authority from the board of the county commissioners. Okay? From the board of county commissioners. Now, newcomer Gavin D. Different. Do you recognize the authority that the Third Temple English Church of England, I'm not saying that you agree with it, but do you see the incorporated authority that we have as a religious society that's backed by statutory law in regard to our religious belief and not just based upon some religious belief based upon the separation of church that was created by the First Amendment? Do you understand that aspect of it? I wait for your response. Once again, do you recognize the authority that we have according to our certificate of incorporation, i.e., our charter, that was filed with the county clerk office, which is the constitutional officer that was authorized what we call the Board of County Commissioners? All right, I can move forward. Okay. So we're talking about the Board of County Commissioners. Okay. Why is the Board of County Commissioners very important? Let's discuss this real quick before we move forward, because we can't move forward without discussing it. So who is the county commissioners and how did they originate? I mean, and I'm not gonna use, they're gonna say, what's your source? Wikipedia is my source because it's baby food. It's presented so a baby can understand it. All right, if you can't understand this, then why go to other sources that speak in a language that you can't understand? And New Jersey Board of County Commissioner until 2020 named the Board of Chosen Freeholders. It's the elected countywide government board in each of the states of the 21 counties. And the 5 counties that have an elected county executive, remember, not the legislative, the executive. And the 5 counties that have an elected county executive, the Board of County Commissioners serve as the county legislator. Once again, that's a violation of law. And the remaining counties, the Board of County Commissioners exercise both executive and legislative functions. That's a violation of separation of powers. Often, when the appointed county administrators or managers overseeing the day-to-day operation of the county government. Do you agree that this is a violation of separation of power? Gavin D. Different, would you agree with me? I'm gonna keep reading while I wait for your response. Origin. New Jersey's former system of naming its county legislative body's board of chosen freeholders was unique in the United States. The origin of the name can be traced back to a law passed by the General Assembly of the Province of New Jersey on February 24, 1713 to 1714, which stated, and we're not even going to get into what they stated, we're going to move forward. So we're going back to the origin of the county freeholders, which were now known as the county commissioners. And why did they change from the county commissioners to the county freeholders? Let's see, because it's very important to understand why. The term freeholder, as originally used in the Board of Chosen Freeholders, originally referred to individuals who owned land, all right, as opposed to leasing it, and an amount set by law and was derived from the term freehold. Chosen means elected. So the elected freehold. We must comprehend that. And it's going back to the New Jersey Constitution of 1776. New Jersey Constitution of 1776. We ain't talking about no other state within the Union. They going back to New Jersey. It said contains the following voter qualification provisions applicable to those voting in New Jersey elections, including county freeholder elections. Okay, separate elections that all inhabitants of this colony of full age who are worthy 50-pound proclamation would clear the states in the same and have residence within the county in which they claim a vote for 12 months immediately preceding the election should be entitled to vote for the representative in the council and assembly and also for all other public offices that should be elected by the people of the county at large. Now they have, in order for that, they have to meet the qualifications, and one of the qualifications was clear estate in the same, meaning that a clear estate is a state in fee simple. Okay? And a state in fee simple. All right. And when they conveyed the land in fee simple, it was based upon heirs and assignees, not heirs of the blood. Okay? We must understand that. because people who have an interest in land, all right, have an interest unlawfully and would have to be reversion or remanded back to the original owners of the land based upon the inheritance that was based upon trust law and not what we call commercial, all right, transaction. All right, we must comprehend that. Let's see, let's go a little further. Controversy in the name change. That's all you want to know. The term freeholder, which is used in no other state, has been criticized as an archaic remnant of the time when only property owners could be elected, which led to white men controlling political power at the time when women and black people were unable to own property on their own. Very, very, very important because we're still in the same situation. Okay? We're still in the same situation, and this goes back to 1776. Okay? Hell, 1713, 1714. All right? So let's reveal why. In the early July 2020, the Jersey Governor Phil Murphy reached an agreement with the Democratic leaders in both state legislative chambers under which the term freeholder would be eliminated and replaced by the county commissioners. You're still the same people. People change, positions don't. Once again, people change, but positions don't. Whether you ain't somebody else sitting in the position or whether you change the name, the requirement of what you still do or the objective of what you still do still remains the same. On July 14, 2020, Burlington County, which was originally one of the towns of the where the Crown sat, was either Harrisburg, Amboy, or Burlington. Okay. So on July 14, 2020, Burlington County Freeholders Director Felicia Hobson called for eliminating and antiquating titles from an era when slavery and racism was tolerated, and announced a plan for Burlington County to stop using the freeholder title on official communications and material. The board planned to replace the title with the county commission by passing a resolution on August 20th meeting. Okay, so now we make the connection between their change from freeholders to commissioner, and we understand why. Because the word freeholder has a lot to do with the time when people identified as black people were considered property as a result of slavery. Very, 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 very important. Okay, are you following along, Gavin D. Different? Do you understand that? Okay. Let's look at the term freehold. All right. Let's look at the term freehold in law because you can't be a freeholder if you understand what freehold means. Okay? You can't have an interest in freehold according to law if you don't know what the word freeholder means, which is now called freeholder. So just look it up. Freehold is in common law jurisdictions such as in England, in Wales, Australia, Canada, Ireland, and 20 states and United States is the common mode of ownership of real property or land and all movable structure attached to such land. Did you hear that? Freehold in common law jurisdiction is the common mode of ownership of real property or land and all immovable structures attached to such land. That must be understood. Okay? That must be understood. It is contrast to leasehold, in which the property reverts to the owner of the land after the lease period expires or otherwise lawfully terminates. For an estate to be freehold, it must possess two qualities. Immobility, property must be land or some interest issued out of an annex to land, i.e., a parcel of estate, and ownership of it must be forever of an indeterminate duration. If the time of ownership can be fixed and determined, it cannot be freehold. It is an estate in land held either in fee simple or fee tail or for a term of life. Now, we just read, according to the real estate book, that the only form of interest in the state and land here in the United States, as well as New Jersey, according to their book, is fee simple. But there's another form of freehold called fee tail. Okay? there's another form called fee tail. So let's define the two forms of freehold: fee simple and fee tail, because it's very important to understand your interest in this particular estate and land, especially if it's a part of an inheritance. All right, we must understand, because we know you got different types of alienation. You got voluntary alienation and you got involuntary alienation. And involuntary alienation is when the heirs are no more and it automatically exceeds to the state because of interstate. And if there are no more heirs, then automatically this goes back to the crown. It goes back to the crown. Greetings, C.A. Murphy. All right, so we define freehold. Let's see if we can get a little bit more on it. Let's see. England and Wales. In England and Wales, before the Law Property Act of 1925, the default position was of a freehold transferable to the owners, heirs, and assignees. This is how they're doing it now. Heirs and assignees, which means successors by inheritance or purchase, gift, respectively. And we know when a purchase or a gift, a purchase is by way of you buying something. This is why our ancestors passed certain laws as a result of people purchasing the land and not following how the law was supposed to be followed based upon you purchasing the land, which is involuntary. Then you have what we call voluntary, which is by gift, respectively, which means you giving it away. All right. Those three words were often included in the conveyance to stress fee simple status. You hear that? Heirs and assignees were those three words to often include in the conveyance to stress fee simple, i.e., a fee simple estate, contrast to a fetal estate, described when transferred by inheritance or otherwise, was limited to lineal descendants of the first person to whom the estate was given, known as an heir of the body or an heir of the blood. Do everyone understand that? Newcomer Gavin, different. Did you understand that right there? That there's a difference between heirs and assignees, which deals with those who possess estates and land called fee simple, and those who fall in the fee tail, which deals with heirs of the body, i.e., dealing with peerages. Do you understand that? Because it's very important in regards to you having some sort of claim and an estate and land. I wait for your response. Right, let's move forward. So we understand and we define freehold in law. We also define, let's define fee simple now, because there's a difference. Fee simple, which is what we call, goes to heirs and assignees, and fee tail, which goes to inheritance based upon those of the what we call by blood. Okay, so what is fee simple? Very important. In English law, a fee simple or fee simple absolute or as a state of land is a form of freehold. Did you hear that? In English law, a fee simple or fee simple absolute is an estate in land, which is a form of freehold ownership. A fee is vested, inheritable, present possessory interest in land. A present possessory interest in land. A fee simple is a real property held without limit of time, i.e., permanently for the duration of your life, under the common law, whereas a high possible form of ownership in fee simple absolute, which is without limitations on the land use, such as qualifiers or conditions that disallow certain uses of the land or subject vested interests to termination. These are called encumbrances. Okay? These are called encumbrances on the fee simple estate. The right of a fee simple owners are limited by government power of what we call encumbrances called taxation, compulsory purchase, police powers, and the street. It may also be limited to further by certain encumbrances or conditions in a deed, such as, for example, a condition that requires the land to be used as a public park. This is called the public domain, with a reversion interest in the grantor if the condition fails. This is fee simple conditions. Everyone needs to understand that, because let's go back to the image. This is right here. Eminent domain power. It's right here. and voluntary alienations due to the eminent domain power do exist, meaning that ain't no heirs. So if you're not an English heir, then that means that you are a foreigner and you fall under the three qualifications of citizenship in North America, which is based upon the Settlement Act of 1701. All right, dealing with Calvin case. This was the Dred Scott case was all about. Then you got the Naturalization Act of 1790, dealing with the founding fathers who were colonies who had nothing to do with some type of nationality or a surname because it was based upon the color of her skin. Then you had the 14th Amendment, which emancipated those who were actually English national, but at that time they were considered property as a result of them being involuntarily alienated from their nationality and their nation and their land. Okay, this came through the Crown Debt Act of 1732, which, as a result of what the colonists did to us, the Crown had to remain convert us to chattel, and now under the Crown Debt Act, all the property that the colonists had to revert back to the crown based upon the debt that they owed. Feudal, it was called feudal relief or free and common soakage, which I'm going to show you in the statute today. So this is what you're subject to. As a result of you don't want to be yourself, that means that it automatically, all your estate, as a result of you not wanting to be yourself, English, Anglo-Saxon, Berbers, then that means all the land and everything on the land is streets to who? The state of New Jersey. And the state of New Jersey is what? A corporation. And corporation, as well as all the states within the state, are corporations based upon their being incorporated under Title 14. All right, dealing with commerce. And everybody who became citizens, all right, became citizens by way of naturalization, which is also called national. So the word national under the definition of United States law and the state's law is called a naturalized person, which has nothing to do with citizenship, but your oath of allegiance to that state. Okay? We must comprehend what's going on. So with that, let's move forward. So we see fee simple. We already defined fee simple. All right. Fee simple was an estate in the land and also what they call a form of freehold. Okay. A form of freehold. All right. One cell. Let's go to fee tail now. What is fee tail? In English common law, fee tail or entail is a form of trust. Did you hear that? Trust dealing with the right to convey land. A trust is a legal relationship in which the owner of property or any transferable right gives it to another to manage or to use solely for the benefit of a designated person. So when you're dealing with property, it means the right to transfer, the transferable right to manage the property on behalf of what we call a beneficiary. Okay, all that involves trust law. So in English common law, fee tail contrast to fee simple is a form of trust established by a deed or a settlement that restricts the sale or inheritance of an estate and real property and prevents the property from being sold, devised by a will or otherwise alienated by the tenant in possession and instead cause it to pass automatically by operation of law to an heir determined by the settlement deed. Did you hear that? Okay? Did you hear that? Fee-tail deeds are in contrast to fee-simple deeds, possessors of which have an unrestricted title to the property and are empowered to bequeath or dispose of it as they wish, although it may be subject to the allodial title of the monarch or of a governing body with the power of eminent domain. Equivalent legal concepts exist or formerly existed in many other European countries and elsewhere, such as telesized, which is in the Scottish language. Do you understand guarantee different of what's just been said based upon the difference between fee simple and fee entail? Do you understand that difference? Please respond in the chat. Wait for your response. Right, let's move it. Let's get there. Fetal. We did fetal. All right, we just did that. Yeah. All right. Fetal in English common law, fetal or intel is a form of trust established by a deed of settlement, and that means that you cannot alienate the land because the land was supposed to pass by operation of law by the settlement deed to what? The beneficiary. The heirs are the beneficiaries to the trust. And that type of trust is different from what they call fee simple. Why? Because it's subject to the allodial property of the minor. Because if there are no heirs, then it automatically is back to the crown. Okay? If there are no heirs, it automatically exceeds to the crown. But New Jersey took out the crown as a result of um um uh it can fall under its sheet now. Because if there ain't no heirs and the crown ain't there, then it falls under what they call abana vacatia, abandoned property. Abandoned property. Let's see how this property became abandoned as a result of them assuming that we're not here. This was lawfully and skillfully done by those lawyers who are now called freeholders, now called commissioners. Okay? They have to go to law school to learn this stuff to be able to steal the land. All right? Because taking land is a concept that originated from common law. Okay? So they know this law better than we do. So let's deal with common recovery. You should be writing these terms down because we're going to go right to the statutory language and the modern day statute and see the same language we're seeing here based upon what we're seeing in Wikipedia, which is nothing more than baby food. Common recovery. A common recovery was a legal proceeding in England that enabled lawyers, i.e., allowed lawyers, to convert a entail estate, a form of land ownership also called fetal, into absolute ownership called fee simple. This was accomplished through the use of series of collusive legal procedures, some parts of which were fictional and others unenforceable, and therefore null and void. It is known it was devised and perfected by lawyers in the second half of the 15th century. The Tarquin case actually increased its popularity. Okay? We must comprehend that. The background. Intels were originally designed to keep ownership of land within a family. Thanks to the effects of the statute de donuts conditionalibus, the intent of the intel could not be broken. This meant that the land in Betel could not simply be sold, transferred, or mortgaged as whatever the current owner did with it. Ownership would automatically pass on the death to these specified by the intel. While Intel performed a valuable function in the 13th century when the donors conditionalibus was enacted, by the 15th century the courts had extended their scope so that they were now perpetual. Social economic conditions meant that landowners were more concerned with being able to freely sell, convey, or mortgage their land. In the second half of the 15th century, common currency was devised a way of circumventing the donuts conditionalibus. The donuts conditionalibus. It's very important that you understand that guarantee different. Why? Because the donuts conditionalibus was the last law passed by Edward I. Let's look at it. Write these terms down. The Donuts Conditionalibus or Estates Tale Act of 1285 is a chapter of the English Statute of Westminster. It originates the law of entail forbidding a landholder to sell his land except to his heirs. Okay? Except to his heirs. Let's go to the background. A former entail has been known before the Norman feudal law and has been domesticated in England. The common form was a grant to a fief, that means a land tenure, and the heirs of his body by which limitation was sought to prevent alienation from lineage of the first purchaser. We must comprehend that. We must comprehend that. So, in fullness, the donors and conditionalibus was a statute passed by who? Edward I to stop land from being considered fee simple. There you go. There you see it right here. Edward I of the Plantagenet crown. There we go. So now Edward I also passed what we call Queen Imperatrice, which was the land forbidding the subdivision of intel land because of their donors conditional above, meaning that it's supposed to be passed to an heir. So what is Queen Imperatrice? What is Queen Imperatrice? See how fluid I am with this? I'm fluent. Would you agree? Gravity different? That I'm fluent in this? Queen Imperatrice is a statute passed by Parliament of England in 1290 during the reign of Edward I that prevented tenants from alienating their lands to others by what the process called subdivision, instead requiring all tenants who wish to alienate their land to do so by substitution. So you can not longer sell the land by subdivision. The only way the land can be conveyed is by substitution, meaning that the same obligation that you had when you transferred the land to another party based upon substitution, you're still under obligated under the same obligation that you was based upon that that was conveyed by the overlord. Okay, the overlord or what you call the landlord. All right. So that means you couldn't subdivide the land based upon Queen Imperatrice because based upon the donors conditions above, it was left for heirs based upon the intel process, which is a form of trust. You call it cestus quae. Okay? You call it cestus quae. Now it says the statute along with its companion statute quorum warranto, and quorum warranto means an order to show just cause. In English American common law, quorum warranto is a prerogative writ issued by a court. Oh, write that word down, writ. All right? But the only way you can have the right to your surname based upon the pedigree of the surname is through a writ issued by the king, i.e., the crown, i.e., me. All right? So if you're not living up to that surname, that's an act of abjuration, which I'll show you in a second. In English American common law, quorum warranto is a prerogative writ issued by the court, which orders someone to show what authority they have for exercising some right, power, or franchise they claim to hold. The writ of quorum warranto still exists in the United States. Did you hear that? It also exists in the United States as well as New Jersey and all the other states. Okay. It also passed in 1290, was intended to remedy land ownership disputes and consequent financial difficulties that have resulted from the decline of the traditional feudal system. Okay? This statute was referred to as His Majesty Rule for buyers and purchasers of land. Once again, it states a statute of our Lord, the King, concerning the selling and buying of land. Okay? We must comprehend what this means. Let's go a little further in Queen Imperatrice. Let's go a little further. Read a little further. By effectively ending the practice of subdivision, Queen Imperatrice hastened the end of feudalism. Queen Imperatrice hastened the end of feudalism in England. We must comprehend that. Although it had already been on the decline for quite some time, direct feudal obligations were increasingly being replaced by cash rents. That's what's going on now. An outright sale of land, which gave rise to practice of delivery by delivery and maintenance or bastard feudalism. It was usually called lottery of season. Now it's called lottery of maintenance, which is a form of bastard feudalism. The retention and control by the nobility of the land, money, soldiers, and servants via direct salaries and land sales and rent payments. By the mid-15th century, the major nobility was able to assemble estates, sums of monies, and private armies on retainers through the post-quote Imperatrice, land management practices, and direct sales of land. It is thought by historians such as Charles Plummer, all right, that this then developed into one of the possible underlying causes of the War of the Roses. You hear that? Other sources indicate the essence of bastard feudalism as early as the 11th century in the form of lottery of maintenance, and that elements of classical feudalism are significant as late as the 15th century. As of 2020, the same statute remains in force in England and Wales, albeit its highly amended form. It was repealed in the Republic of Ireland in 2009 and has an impact in Australia as well as colonial America and thereby modern, what y'all? The United States. We must comprehend of what's going on. All right. So first, let me just cancel out uh, those who are not heirs of the body. Okay. The background. Prior to the Norman Anglo-Saxon conquest 1066, the Anglo-Saxon of land succession was customary land, or folk land, as it was called, held in a allodial title by the group. Okay, by the group, meaning that the group held the land. It was probably of little reference when the titular head of the clan or family died. Traditionally, land continued to be held in the community by the group. The exact nature of allodialism as it exists in Anglo-Saxon England has been debated, but to no definite end. On one side, it has been argued that in the Marx system, Saxon allodialism was highly idealistic, socialist, and communitarian state. Countering this utopian view was Numa Dennis Fustel de Cunnilingus in his essay, The Origin of Property and Land of Frederick William Maitland, who found it to be inconsistent with extant Anglo-Saxon documents of pre-Norman time. After the conquest, the rule became one of primogeniture. Inheritance meaning that the eldest surviving son became the sole heir and baronial estate. That's very important because of the word primogeniture. Let's review that real quick before we move forward. What is primogeniture? Primogeniture is the right by law or custom of the firstborn legitimate child to inherit the parent's entire or main estates and preference to shared inheritance among all of some children, any illegitimate child, or any collateral relative. In most contexts, it means the inheritance of the firstborn son to agnatic primogeniture. It can also mean the firstborn daughter, matrilineal primogeniture, or firstborn child, absolute primogeniture. Why is this important? Because it was dissolved by Thomas Jefferson. It was dissolved by Thomas Jefferson. But they didn't want me coming back. Let's prove it. Right here. Everybody listen. In British North America, it didn't say America, it said in British North America. You know, British was overseen by the monarch. It said in British North America, the colonists followed English primogeniture laws. Did you hear that? Carol Shamaz argued that issue of primogeniture, dower, courtesy, strict family settlement, and equity, collateral kin, and unilateral divisions of real and personal property was fully developed in colonial courts. The American differed little from English policies regarding the statute of widow, widower, and lineal descent. The primogeniture laws were repealed at the time of the American Revolution. Thomas Jefferson took the lead in repealing the laws of Virginia, where nearly three-fourths of tidal water lands and perhaps a major of western land were entailed. When you go into tidal water, you're dealing with riparian rights and littoral rights. Riparian rights dealing with land, water boundaries that exist between one body of tidal, one shoreline and the other shoreline, dealing with something that is not great and distant versus littoral right, which deals with two bodies of shorelines dealing with a vast body of water. So you're dealing with riparian rights and littoral rights, and that was intel for all heirs that were preserved through their hereditary surnames based upon their relationship to their nation, based upon their oath of allegiance to their nation, which Thomas Jefferson severed. Why would you sever it and your last name is Jefferson? My last name is Jefferson, and you didn't see me sever my tie in allegiance to my forefathers, all right, or my nation. Why? Because to do so will be an act of abjuration. How many of you know what that word means? act of abjuration? Let's define that before we move forward. Act of abjuration. Abjuration is a solemn repudiation, abandonment, or renunciation by or upon oath, often the renunciation of citizenship or some other right or privilege. The term comes from the Latin abjurate, means to forswear. Okay? This is what all you have doing. I'm going to prove it. Abjuration of the rim. Abjuration of the rim was a type of abjuration in ancient English law. The person taking the oath swore to leave the country directly and promptly, never to return to the kingdom unless by permission of the sovereign. This was often taken by fugitives who have taken sanctuary. So when you go somewhere other than your mother country, you become a foreigner and you're taking refuge in another country, which makes you a foreign national because you have given up your allegiance to your national country and now became a subject of the so-called foreign nation who now took you on, which makes you a ward of that state. Does that make sense, Gavin D. Different? Does that make sense to you based upon what just said in the last 5 or 10 minutes? Please respond in the chat. Okay, let's move forward. Now, just a little bit more on the terms and conditions. Are you writing these terms down? Because if you're not going to be able to understand it when I go into the area I'm about to go into now. That's why it's important to write those terms down. All right, and possibly when you get to go on your own accord to be able to use those terms that you wrote down and use the lesson that you're viewing now in regards to the area I'm about to go into now to further elaborate and qualify what's being said based upon the statutory law that allow us to do what we do based upon that operational law in regards to the estate that was stolen by the freeholders, now called the commissioner, based upon the complaint that was filed on behalf of the heirs, which was filed by your king. All right? So it's very important to understand and write these terms down in lieu of what's being spoken about in regards to why those who are not, who have committed an act of abjuration, you will be removed from this land. You will be removed from this land. I didn't make these laws. I'm only following what the ancestors said. Okay? So, don't take it personal. All right? Please don't take this personal. Let's see. Where else I want to go? Heirs of the body. In English law, heirs of the body is the principle that certain types of property pass to a descendant of the original holder, recipient, or grantee according to a fixed order of kinship. Upon the death of the grantee, a designated inheritance such as a parcel of land, a peerage, or a monarchy passes automatically to the living legal natural descendant of the grantee, who is most senior in the descent according to primogeniture. Male beings preferred, however, over their sisters regardless of relative age, and thereafter the property continues to pass to subsequent descendants of the grantee according to the same formula upon the death of each subsequent heir. All right? We must comprehend that. Baronies created by writ of summons to Parliament usually descend to the heirs of the body of the grantee and may thus be inherited by females. By the terms of the Acts of Settlement 1701 and the Act of Union 1707, the crowns of the United Kingdom of Great Britain and Northern Ireland descended to the heirs of the body of the electors of Sophia of Hanover who are not Catholics or married to Catholics, subject to the subsequent modification of Parliament and His Majesty's Declaration Act, Abdication Act of 1936. Okay, very important. That's not our peerage based upon those created under the Act of Settlement in 1701, because all those who come from that conveyance of property were subject to the laws governed by those who are foreign nationals. Okay? Very, 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 very important. So once again, an heir of the body is subject to that conveyance of land that deals with intel of land, and that's based upon your peerage, your hereditary peerage. Do anyone know what that means? Let's see. Hereditary peerage forms part of the peerage of the United Kingdom when they inhabited from England. Okay, very important that you comprehend that. Why? Because they didn't want to leave that out. So let's go to the origin. All right, let's go to the origin. The heritage peerage, as it now exists, combines several different English institutions with analogues from Scotland and Ireland. So they're different. English earls and Anglo-Saxon institutions around 1014, England was divided into counties, i.e. shires, or largely to fend against the Danes, which were Vikings. Each shires were led by the local great men called the earls. The same men could be earls of several shires. When the Normans invaded England, they continued to appoint earls, but not for all counties. The administrative head of the county became the sheriff. Earls began as office with a prerequisite of a share of the legal fees, and the counties they gradually became honors with a stipend of 20 pounds a year. Like most feudal office, earldoms were inherited, but the king frequently asked earls to resign or exchange earldoms. Usually there were few earls in England, and they were men of great wealth in the shires from which they had title, or an adjacent one. But it depends on circumstances during the civil war between Stefan and Empress Matilda. 9 earls were created in 3 years. That's what's called the anarchy. With the white ship, that goes into the history dealing with why the Clarendon Constitution and the sides courts was created, which were the courts we have here today and what we call North America. Okay? We must comprehend that. I don't have time to explain that as a result of the time frame. Okay? This also involves William the Conqueror, who invaded the Anglo-Saxon British territory, which is called England, and his grandson called Henry II, great grandson, as a result of marriage, only because of marriage, because his son William Allen was supposed to marry Fulk V's daughter Margaret of Anjou, but because William Allen died in the White Ship, the marriage continued with Matilda, what's her name? Matilda of Germany, all right, who married uh, Godfrey V of Anjou, the son of Fulk, the ruler of Jerusalem. Okay, all right. So this is what it's all about, and all these heirs dealing with the inheritance of the estates trickle all the way down to Henry III. All right, and Henry III was a son of who? Edward, the father of Edward I. We see right here. When Henry III or Edward I wanted money or advice from his subject, he would order great churchmen, earls, and other great men to come to his great council. This means the king's council. All right. And Henry III was the father of Edward I. And Edward I was the father of Edward II. Edward II was the father of Edward III. And Edward III was the father of um, um, John Gaunt. And John Gaunt was the one who gave rise to the House of Yorks and then the House of Lancaster, which were the cadet branches that warred against each other, which started what we call the 100-Year War. Very, very, very important that you comprehend that. Okay? You follow along, Galvin D. Different? Galvin D. Different? Or do I need to explain anything? Let's deal with alienation. Very important. We already discussed alienation, voluntary alienation. Now we're going to talk about alienation. Let me just show you again. It's according to the state of New Jersey. I didn't write this. Involuntary alienation of title is only done through what they call interstate, right? Interstate. You see it right here in the diagram. right here. What started it all was interstate. That means that the English heirs gave up their birthright by wanting to be somebody else involuntarily. You have a choice to be who you want to be. All right? But that's not going to save you. All right? So when you not being who you are, then you actually die. You actually die. When you know heir, that means the family line dies out. Everyone must understand that. Okay? So we're going to deal with the involuntary alienation of the English heirs, i.e., the Anglo-Saxon Berbers, and the result of our own ignorance, not understanding our real estate law. All right? It's very, very important. All right? So let's go look at alienation. In property law, alienation is the voluntary, you hear that? Act of an owner of some property to dispose of property, while alienability or being alienable is the capacity for a piece of property or a property right to be sold or otherwise transferred from one party to another. Most property is inalienable, but some may be subject to what we call restraints on alienation. Okay? Once again, I repeat, in property law, alienation is the voluntary act of an owner of some property to dispose of the property while eligibility or being eligible is a capacity for a piece of property or property right to be sold or otherwise transferred from one party to another. That's voluntarily. But what about involuntary act? Voluntary. When there are no heirs, then it automatically exceeds as a result of interstate. That's the problem. Why? Let's look at it. In English, in England, under the feudal system, land was generally transferred by subinfeudation. What is subinfeudation? It's a practice by which holding land under the king or other superior lords carved out new distinct tenures in their turn by subletting and alienating a part of the land to somebody else, but they're not supposed to. So once again, in England, under the feudal system, land was generally transferred by subinfeudation, and alienation required a license from the overlord. Okay, we understand that under Queen Imperatrix, that was abolished. All right, based upon the donors' conditions above the land being intel, how they stole it from intel land by way of alienated, by way of claiming that you don't exist no more. Okay, you do not exist no more because there were restraints on alienating property that actually belonged to heirs. And the property that belongs to heirs that there was a restraint put on in lieu of understanding property law was called intel. I'm not making it up. Let's just see. What is restraint on alienation? Who else is able to solve this Rubik's Cube like I'm doing? Listen. A restraint on alienation in the law of real property is a clause used in the conveyance of real property that seeks to stop, prohibit, forbid, eliminate the recipient from selling or otherwise transferring their interest in the property. You all have an interest in this property, and the only way you can stop that interest from being violated is by understanding your right according to the difference of the two types of form of freehold. Intel and fee simple. Okay? Intel and fee simple. Fee simple is based upon heirs and assignees who manage by library of maintenance, and those who are intel, which is managed by what we call library of season, which means delivery of possession based upon two forms, law and deed. All right, our ancestors didn't create no deed. They wrote it in law and said that when you guys wake up, you can go get this land by following the process that we put in place based upon the intel estate, which is a restraint on the alienation of your vast estate here in North America. Because it said, and I reflect and I quote, restraints on alienation in the law of real property is a clause used in conveyance of real property that seeks to prohibit the recipient from selling or otherwise transferring their interest in the land. Okay? Interest in the property. Under the common law, such restraints are void as against the public policy of allowing landowners to freely dispose of their property. Perhaps the ultimate restraint on alienation was what? Detail. Did you hear that? Did you understand that? Guarantee different. That the ultimate restraint on those who were able to alienate your land, whether it was voluntary or involuntary, was detail. Do you agree with that? Wait for your response. It's needed. Hold that thought for a second. All right. Thank you for your response. Guarantee different. All right. Restraints on alienation, the highest form of alienation, restraint was detail. All right. Very important. So if that's the case, let's define crown land. Okay. Crown land. I'm a computer right here. Crown land, also known as royal domain, is a territory area belonging to the monarch which personifies the crown. It is equivalent of an entail estate and passes with the monarchy, being inseparable from it. Today, in Commonwealth Rim, Crown land is considered public land and is apart from the monarch private estate. I repeat, Crown land, also known as the royal domain, is a territory area belonging to the monarch who personifies the crown. It's equivalent of an entail estate and passes with the monarchy being inseparable from it. That's the result of ain't no more heirs. So it automatically goes back to the crown. Why? Because the concept of escheat is the concept of the crown. Let's just see. The crown. Now you see now certificate of incorporation, gravity different, and look what it says on Wikipedia. The concept of the crown as a corporation soul, a natural person, developed first in the Kingdom of England as the separation of the physical crown property of the kingdom from the person and personal property of the monarch. It spread through English and later British colonization and now rooted in the legal lexicon of all 15 Commonwealth realms. Now they are called republics. The various dependencies of the state free associated with them is not to be confused with the physical crown as you see over in the United Kingdom. Right? Very important. All right, let's go to the concept. The concept of the crown took form under the feudal system, though not used this way in all countries that had this system. In England, all rights and privileges were ultimately bestowed by the ruler. Land, for instance, was granted by the crown to lords in exchange for feudal services, and they in turn granted the land to lesser lords. One exception to this was common soccage. Owners of land held as soccage held is subject only to the crown. When such land became ownerless, they are said to exceed, i.e., return directly to the ownership of the crown, i.e., crown land, because it's personified by the crown. And we know the word personified means to incarnate. Bona vacatina is the royal prerogative by which unowned property, prominently unclaimed inherited, becomes the property of the crown, which the state is assumed to be the crown. Do you understand that? Gavin D. Different. Please respond in the chat. So here. Let's go back to Queen of Taurus. Queen of Taurus was a law passed by our ancestors Edward I to make sure that there would be no subdivision of land, i.e., alienating the land, because it was supposed to pass by operation of law by way of what we call entail. All right. And if it didn't pass, that means there was no heirs, and automatically it ceased to the crown, i.e., me, personified the crown by way of what we call incorporation. Okay. So it's very important because this brings up the word seniority. Okay. Seniority. Let's look at this word real quick. And in fact, I'll just go right to it. Signory. Very important word. Guarantee different. Please write this word down. Signory. In English law, signory or signory, French signeur, is the lordship authority remaining to the grantor after a grant of an estate in fee simple. It's called nullitaris sequenere. No land without a lord. Once again, English signory or signory is the lordship's authority remaining to a grantor after grant of a state and fee simple. So the fee simple estates, which were now conveyed by way of freeholder to freeholders, which is now called commissioners, are able to be reverted by way of remandment to the original grantor, which is the original conveyor, which is based upon the obligation of free and common associates, which if you broke that, it was supposed to be returned by way of you're breaking the agreement of fees, which is returned to the Lord or the Lordship. Everyone needs to understand that. Seniority is the Lordship's authority to remaining to the grantor after the grant of estate in fee simple. Okay? Nulla terra sequenere. No land without a king was a feudal legal maxim where no other lord can be discovered. The crown is lord and lord paramount. Once again, where no other lord can be discovered, the crown is lord as lord paramount. The principal incidents of signory were a feudal oath of homage and fealty, a quiet or chief rent, a relief of 1 year rent, and the right of escheat. In return for their privileges, the Lord was liable to forfeit his right if he neglected to protect and defend the tenant or did anything injurious to the feudal relation. Y'all better be paying attention. Every signatory now existing must have been created before the statute of Queen Imperatrix, which forbade the future creation of estates in fee simple by subfeudation. Did you understand that, Gavin D. Different? Did you understand that? I need to know. Did you understand that? Please say so in the chat. It was written in law before Queen Imperatrix. It was written in law that which forbade the future creation of an estate in fee simple by subfeudation, and the highest form of ownership in North America is what? Fee simple, right? And thus forth, there is no allodial land. Because if it's allodial, it means there ain't no tenures given out to heirs. That means it is streets what? To the crown, because the crown is personified by the monarch by way of what we call crown land. Okay? We must comprehend, you understand, so therefore you're in the right state of mind. Okay, let's continue. So we understand signatory right is based upon the right of what? A lordship, and the highest lordship is Lord Paramount, which is the crown. Okay, which is the crown. So let's see, and defines the seniority right based upon that of Queen Imperatrix that prevents the right or forbids the right of selling land that actually belongs to heirs, okay, of the body. Let's see. Lordship. Let's define it. Lordship. A lordship is a territory held by a lord. It was a land estate that served as the lord's administrative and judicial unit in a rural area. It originated as a unit under the feudal system during the Middle Ages. In a lordship, the functions of the economic and legal management are assigned to a lord who at the same time is not endowed with indispensable rights and duties of the sovereign. Lordship is in essence and clearly different from a fief, and along with the allot, it is one of the ways to exercise right. Once again, along with the fief, along with the allodial title, the land or the that's taken to you by way of your charter or a deed is one way to exercise your right to convey the land. Okay, so you must have a fief, i.e., a deed. What is a fief? I didn't mean to pull that. Let's just read it. What is a fief? A fief was a central element. A fief was a central element in medieval contract based on feudal law. It consisted of a form of property holding or other rights granted by an overlord to a vassal who held its fealty in fee in return to form feudal allegiance and service of payment. You understand that? Why? Because you were on allodial land. You pay taxes. Why? Because you are on the allodial land. All right? It's one way of exercising that right. Let's continue. Nulla sans sequere, no land without a lord, was a feudal legal maxim where no other lord can be discovered. The crown is Lord Paramount. The principal instance of signatory was a feudal oath of homage, fealty, choir rent, chief rent, relief, and 1 year rent, and the right of his chief. In return for the privilege, the lord was liable to forfeit his right if he neglected or based upon that obligation. Every signatory now existing must have been created before the statute of King Imperatrix, which forbade the future creation of estates to be simple by subfeudation. Freehold lands may be enfranchised by conveyance of the signatory to a freehold tenant, but it does not extinguish the tenant's right of commons. All right, very important. The tenant for life of a manor is empowered to sell the signatory of any freehold land within the manor, and the purchase of the signatory of any part settled land being freehold land is an authorized application of capital money arising under the act, meaning dealing with commercial activity. How did we know that? Let's go back to alienation. Let's go back to the word alienation, because the land was not supposed to be alienated, right? It was not supposed to be subject to freehold, which is fee simple conveyance. Let's prove it. And let's see how they create a law to protect their conveyance and freehold as freeholders. All right, let's see. Oh, this is what I want to read right here. English common law traditionally protected freehold landowners from unsecurity creditors. Did you hear that? Did you hear that? English common law traditionally protected freehold landowners from unsecured creditors. All right, check this out. Check this out. From all right. English common law traditionally protected freeholder landowners from unsecured creditors. And in 1732, Parliament of Great Britain passed legislation entitled An Act for More Easy Recovery of Debt and His Majesty's Plantations and Colonies in America, sometimes known as the Debt Recovery Act of 1732, which required all land and slave property in British America to be treated as chattel for debt collection purposes, and thus removed the shield from creditors which had protected large landed estates and which continued to protect those estates in Britain. However, the act was amended within a decade to allow colonial legislators, particularly in the Southern American colonies, to again protect real estate transferred in fee tail or inherited through primogeniture. All right. So the ones who really owned the land in fee tail under primogeniture was us. But we based upon the Debt Recovery Act of 1732, we were enslaved by those Southerners, and as a result of that, the Crown had to claim us back under the Debt Recovery Act by treating us as chattel property because we were considered property. Because we couldn't own property, so we fall under the terms of chattel property. But when we came under the Debt Recovery Act, we were not subject to the debt that was subject to the status of what we call legal fiction as property under the slave master, but now we came under subjectivity on what we call the crown. And any slave that was in the soul of England became free. Did you understand that? Gavin's different. Do you understand that? So the freeholders were the ones who enslaved the so-called slaves who were considered slave property until the Slave Debt Act of 1732, okay, which brought us back under the protection and the birthright, which was practiced prior to that, which was the practice of fee-tail and primogeniture in the Southern American colonies. And this is the reason why we were fleeing the Southern American colonies as a result of that. Did you understand that? Guarantee different. If you do, we can move on. So you have what we call Lord. So you got lordship, and now we're going to define Lord paramount. I had it twice. Lord paramount. Let's look at that. Once again, we accept gifts in regards to free and common soakage here at the Third Typical English Church of England by sending it to the Third Typical English Church of England or $ Clifford Jefferson L. Once again, the Third Typical English Church of England or $ Clifford Jefferson L. is not mandatory based upon it's a gift. All right, but it will become mandatory once the king come back. So whether your patronage be done now or later. All right. So it says Lord Paramount. Lord Paramount is a term of art in feudal law describing a overlord who holds his own fief from no superior overlord. It is thus described as a person who holds a lordio title. Write that down. Owning no soakage or feudal obligations such as military. This was distinguished from Methnay's lord, who held a own fief from a superior lord. So Lord Paramount was different from a landlord. Okay? We must comprehend that. And the Lord Paramount, which was the crown, owns the allodial land. Did you understand that? Guarantee different. All right, let's move forward. So once again, let's go to allodial land. Read it again for ourselves to see that there is no allodial land in the United States of America. Or is it? That's the question. But we're reading here, under the allodial land, most property ownership in the common law jurisdiction is fee simple. In the United States, the land is subject to eminent domain by federal and the state and parts of local government and subject to the imposition of taxes by state and or local government, and there is thus no true allodial land. Land is held of the crown. You hear that? Land is held of the crown. Yes, similar chief paramount. Absolutely right. All right. So it's very important that they just said that there's no allodial land because all land held in North America is fee simple, and fee simple was a result of conversion of intel estate by way of those freeholders who considered to have an interest in land by way of what we call freeholder states. Okay, we must comprehend that before I move further on into this lesson. Okay, so now that you do, let's move further on into this lesson. All right. So is there allodial land or not? Let's see. Let's see what the truth is. Let's look at the truth. Did you write those terms down for me, Gavin Different, and all the terms we use today? Because you're going to need them based upon where we're going right now. Did you write those terms down? Because you're going to need them based upon where we're going to go now. Because we're going to qualify what Wikipedia said based upon how the land can be conveyed by operation of law, and we're going to show you the law based upon what Wikipedia said about how the land can be conveyed by way of the law, which we're going to use. I'm so glad you was able to join us today. It is a pleasure. Have you ever seen or heard any teachings like this in any platform, channel, website, YouTube, whatever? Have you ever heard any lessons like this explained so detailed and so formal? Please respond. Wait for your response. Okay, while I wait for your response, I'll move forward. New Jersey revised statute, the 2023, dealing with property. Gift, grants, conveyances by the state allodial. But we just read it on Wikipedia. Okay, so uh uh you don't understand? So you're saying you don't understand? Please explain. Okay, while I wait for your response, it says Title 46 of New Jersey Revised Statute, gift grants conveyances by the state is allodial. Let's see what they say. All gift grants or conveyances made prior to and after July 4th, 1776, of an estate of inheritance by letter patent under the great seal of the state, or any other manner by the state, by the legislator thereof, or by any commissioners, i.e., your freeholders, or agents of forfeited estates, or by other lawful competent authorities under the state, shall be and remain elotio, and no feudal, or shall forever be and continue in free peer elotium only, forever discharged of all feudal tenures and the ancestors thereof, and all other services whatsoever. So if that's the case, that means that according to the statute, all land is held by by Lord Paramount. Would you agree? Guarantee different. Would you agree, based upon the statute, being that the land is allodial, that means that the land will be owned by um, the Lord Paramount and not the lordships? Okay, because the lordships are not actually operating like they should be based upon the contract, because they're the one who stole it, namely the commissioners or freeholders. So do you agree, based upon Title 46 of New Jersey Revised Statute 3-6, that the land is allodial? And if the land is allodial, that means that the authority belongs to the Lord Paramount, meaning the crown. Okay, that's good. All right. All right. So as we can see here, Wikipedia just told you that the United States don't own the land, nor do the state of New Jersey own the land, because it's one of the states within the union. So that would only mean that the land belongs to the one who's Lord Paramount, and the one who's Lord Paramount will be the crown. And that will be me, because I incorporated as Lord Paramount, because I represent the crown, and the crown represents crown land, which personifies the crown, which is the intel. And as a result of that, that means that I am the corporation soul. All right. So if that's the case, we now know that the land is allodial. All right. Now let's go back to understanding why the land is allodial and why there is no heirs. Let's see. Let's see. Let's read the court case right quick and show you why it's important to understand your surnames. All right. How important your surname is. I had y'all for a while, so I ain't gonna try to hold you too long. Austin versus Collins, 1886. All right, this is the case. 1886, concerning wills, names, and arm clause, forfeiture license of college arms, declaratory judgment. Under order 25 R5, the court has now jurisdiction to make a declaratory order, though no consensual relief is claimed, but such jurisdiction will be exercised with great caution. A name and arm clause contains a proviso that in a case that the advisee should refuse or neglect within 1 year to take, use, and bear the surname of A, or should at any time afterward discontinue to use or bear such surname or arms, then in every such case, immediately after the expiration of a year or immediately after such discontinuance, the devise should determine and become void. The devisee assumes the surname and also use his best endeavors to comply with the direction as to the arms, but fail to obtain a grant from the Herald College of the right to use the identical arms used by A. This is very important, because what is the Herald College? Let's see that. College of Arms. Let's see that. So you must have a right to use the surname, okay, based upon your arms, your coats of arms, okay? You just can't have a surname and claim you have an interest based upon your surname, because the surname that you have, based upon the status of the surname, based upon your peerage or the hereditary right, may be different classification. You might not be of the royal family. You might not be of a noble family. You might be of a peasant. You might be of a servant. You might be of a foreigner. That's yet to be discussed. All right. So now that's why it's being discussed now. The College of Arms, or Herald College, is a royal corporation consisting of professional officers of arms within the jurisdiction of England, Wales, Northern Ireland, and some of the Commonwealth rims. The heralds are appointed by the British sovereigns and are delegated authority to act on behalf of the crown in all matters of heraldry, the granting of new coats of arms, genealogical research, and the recording of pedigrees. Y'all better listen to what I'm saying. Founded by the Royal Charter in 1484 by King Richard III of England, the college is one of the few remaining official heraldic authorities in Europe. Who is King Richard III? Let's see. Richard III was the King of England from the 26th of June 1483 until his death in 1485. He was the last king, I repeat, the last king of the Plantagenet dynasty and the cadet branch of the House of York. His defeat and death at the Battle of Bosworthville marked the end of the Middle Age of England. All right, did you hear that, y'all? Richard was created Duke of Gloucester in 1461 after the accession of his brother Edward IV. This was during the period of what we call the War of the Roses. Now, you can't tell me I don't know what I'm talking about. You can't tell me I don't know what I'm talking about in regards to understanding how important it is to trace your surname back to the heredity where it originated from. Okay? So let's go back to the court case to qualify it. All right? Just going to read a little bit about this. It was held that an estate of the devisee had not been divested by the failure to obtain a grant of the identical arms used by A. Symbols that a name and arms clause is required taking of arms by a proper grant from a proper authority, namely the College of Arms, and is not satisfied by a mere voluntary assumption of a coat of arms. Did y'all hear that? Did you hear that? Thank you, Gavin D. Different. Full circle. Mr. Austin, who died on the 18th of June, 1855, by her will, dated the 17th of January, and the same year, divested certain real estate to the use of the plaintiffs then and in the will called William Chandler Roberts and his assigns. Remember, heirs and assigns, not heirs of the body, for his life, without impeachment of waste, with remainder to the use of the first and every other sum of the plaintiffs successively, according to their respective seniorities. Intel. You hear that? They're saying intel. When it's fee simple, you don't have a right to intel because you don't go back far enough. Far enough. With diversity remandering over and the testatrix declared that every person who should become entitled as a tenant intel mailed or an intel to the actual possession or the receipt of the rents and profits of the premises therein before divided in strict settlement, and who should not then use and bear the surname and arms of the testatrix late husband M. Major Austin should within 1 year after he should so become entitled, or being an infant within 1 year after he should attain the age of 21 years, unless in the said respective case any such person should be prevented by death, take upon himself, if and use in all of these in writing which he should sign, and upon all occasions the surname of Austin together with his own family surname, and also quarter the arms of Austin with his own family arm, and should within the said year, unless prevented by death, apply for and endeavor to obtain a proper license from the crown, or take such other steps as might be requisite to authorize him to take such use and bear the said surname and arms of Austin. And further, that in case any such person should refuse or neglect within the said 1 year to take, use, and bear such surname as aforesaid, or should at any time afterward discontinue the use and bear such surname or arms, then and in every such case, immediately after the expiration of the said 1 year, or immediately after the such discontinued as aforesaid, as the case might be, if a person who should so far as the time being refuse or neglect or discontinue as the aforesaid should be tenant for life, the limitations therein before contained to the use of such person and his assignees during his life, being so far as the plaintiff is concerned, the limitations herein set forth in that behalf should determine and become void. And if the person who should so for the time being refused, neglect, or discontinue as aforesaid should be attended entail, male or entail, then the limitations should absolutely determine and become void. And the said respective case, the said premises therefore divides in strict settlement should immediately go to the person or person next in remainder under the limitations therein contained, precisely in the same manner as such person be tended for life were dead, and being tended entail male or entail were dead, and there were a general failure of issuing inheritable under such limitation entail male or entail respectively. Do y'all understand what's being said? You just can't have a name and not associate the name going back to the hereditary origin where it originated from based upon your status and pedigree. We must comprehend that part. We must comprehend that part. Why? Let's come to our closing. New Jersey revised statute title 46:3-5. Alienation of freehold statute Queen Impetuous Terrum. This was passed by who? Edward the First. Edward the First. They're showing you what they've done to the heirs. They stole the land. They stole the land. All right, they stole the land from us. And our obligation to prove how they stole it. Here's the proof right here. Alienation of freehold. We already know what freehold is. We already know what their freeholders are. We know that freeholders only interest in the land is fee simple, and we know fee simple was a result of common recovery, which was a legal process for those who have freehold based upon the status as a freeholder to steal it. Okay? It says here, from and after March 18th, 1795, any freeholder, you hear that? May give, sell, or alien the real estate whereof he is or at any time shall be seized in fee simple, which is the common recovery practice. So that means you stole it, you put it right here in the statute, and that's why you changed your name from freeholder to commissioner, because under the statute we just told you under 46:3-6, it says the land is allodial and remain under allodium land. All right, based upon Lord Paramount. But it says right here, you stole the land and allowed everybody who had the interest in that land fee simple by way of heirs and assignees to be able to sell it to anybody else under the same process. All right. Totally in violation of what? Queen Impa Torres. Would you agree with that, Gavin D. Different? Would you agree with that statement right there? Please say yes or no. All right. While I wait for that response, New Jersey Bar Statute 2023. All right. 2023. It states until abolished. They state right here. Whenever a conveyance, will, or instrument in writing shall hereafter be made whereby any grantee, devisee, or other person shall become seized in law or in equity of such estate in any real estate as under the statute of who? Edward the First entails. This they don't is conditionalibus. This right here. What is this doing in New Jersey by statute? This. He said that it originates the law of entail forbidding landowner to sell his land except to an heir. So what the hell is New Jersey doing right here then? if that is the case. What the hell are they doing? Because it said right here, estates, entails, and abolished. Whenever any conveyance, will, or instrument in writing shall hereafter be made, whereby any grantee divides to other person shall become seized. Seized means to take by either force or by by deceit, etc. It's such what we call the statutes of fraud. Okay. So it says, whenever any conveyance, will, or instrument in writing shall have to be made, whereby any grantee divides to other persons shall become seized in law or in equity of such estate and any real estate as under the statutes of 13 Edward I called the statutes of entail would have been held in fee tail of any type or character. Such conveyance, will, or instrument shall vest in estate now and fee simple, and such grantee divides to other person. Do you see how they're still in our state? Because you're not attaching yourself back based upon the laws of heredity. Okay, you must understand that, and that depends upon your status. If you are a foreigner, if you are a peasant, if you are a military wing, if you are a tenant who tills the soil, if you are a noble, or if you are of the royal family. All this is dependent upon you understanding your interest in this estate, which was abolished by the state of New Jersey going back to Edward I, which I am of the noble family because I bear the surname Jefferson, which is Godfrey, which gave birth to the Angevin crown, which was birthed by the Plantagenet crown under Godfrey the Fifth Calabrian Jew, son of Folk, ruler of Jerusalem. So, in fact, in order for you to return to Jerusalem, you must honor your Lord. This is why New Jersey is called what? The Garden State. Okay? So in closing, they stole the land to fee simple by way of common recovery. All right? But it says here, in closing, fines and common recoveries abolished. From and after June 12th, 1795, no fine or common recovery that has been or shall be entered, made, had, or suffered in any court of record of the state shall operate or be construed to be a conveyance or assurance of a real estate, or in any way bar the issue of entail or the reversion or remandering of their lawful claim and entries, and in any uses, customs to contrary, in any wise is notwithstanding. Y'all better realize what's coming down the pipe. They just said common recovery don't exist anymore. So if that's the case, let's define common recovery. Common recovery was a legal process preceding England that enabled lawyers to convert entail estate into fee form of land ownership and fee tail into absolute fee simple, which is how the freeholders own it. Freeholders hold the land fee simple by changing it from fee tail, i.e. entail, under common recovery practice created by lawyers. So as a result of that, our ancestors passed laws to revert that estate back to you by way of abolishing common recovery, as you see here in the New Jersey by statute. Why? Because as I close out on this statute, 46:3-2. New Jersey by statute 2023. Anybody who enjoyed this lesson, give me a thumbs up. Certain tenures holdings turn to free income and soakage. Tenures of honors, manors, lands, tenements, or hereditaments. So if you think you're an heir, you got a right to some type of tenement in the land, whether it's a manors or honors of an estate of an inheritance, it must be at the common law, held either by the Kingdom of England or under the body of politics that was governing under the Kingdom of England through the incorporation, through their certificate of incorporation, which is the form of personification, going back and before July 4th, 1776, declared by Section 3 in the Act entitled an Act concerning tenure. So that means that before July 4th, 1776, all the land that was based upon tenures going back to the inheritance must be based upon the Lord Paramount, which is the King of England, which I'm representing in this day of time. And I actually have a claim on the record for those who claim to still hold their allegiance to the king and not committed the act of abjuration as against their king and against their birthright, which was based upon practicing and honoring and showing that you have an affiliation to some type of peerage here within the kingdom of England. Okay? You must understand that. And with that, I think I covered everything. So I'm going to stop sharing my screen. I'm going to open the floor for questions. Is there any questions that you might have? Gavin D. Different? Any questions? Please let me know if there are any questions from anyone on the floor in regards to today's lessons and in regards to your right to the inheritance based upon your affiliation with the hereditary requirements based upon the periods that was handed down by our ancestors, starting with the Plantagenet crown. Any questions? I don't want to see no pictures. I don't want to see no icon. I want to see languages. I want to see verbiage. Okay? Any questions? If you don't have questions, then I mean I'm gonna hold you accountable that if you know. Because watching these videos don't mean nothing to me if you don't comprehend what it is, because you're responsible to know. Okay? You're responsible to know. Knowing determines your station, your status, your peerage, your hereditary right here in my kingdom. Okay? Gavin D. Different, how did you enjoy the lesson? That's my question to you, because everybody else I'm familiar with on the platform. Oh, I'm glad you said that. I'm glad you said that. Let me say it. Check this out. It's for you. Privacy right. Right of privacy. Right of privacy. Section 50. Right of the privacy. A person, firm, or corporation that uses for advertising purposes or for the purpose of trade the name, portrait, picture, likeness, or voice of any living person without having first obtained a written consent of such person, or if a minor of such minor parent or guardian is guilty of a misdemeanor. Why do I say that? Because dig in your pocket right now, guarantee different, and look on the driver license, and you will see on it, it says that not for real ID purposes. Do you have the present instrument called a driving license or an ID that's recent? And tell me, do it say on it not for real ID purposes? Please respond in the chat. Okay, so if yours say that, then that means you're in a real sticky situation, right? Because if it says not for real ID purposes, and you know the motor vehicle is an instrument for not only the purpose of driving, but it's also an instrument identifying you. Because when they stop you, they don't ask you for a birth certificate. They don't ask you. The only true identification card that they truly have, or instrument, I should say, is a birth certificate or that driver license. Okay, that driver license is what they use for you to enter state buildings, county buildings, or municipal buildings. Okay, but on it, it actually says that it's not for real ID purposes. In order for someone to have jurisdiction of law, they must have personam jurisdiction before they have subject matter jurisdiction. And if you've given that ID and it says on it that it's not for real ID purposes, then you're agreeing to how they are identifying you based upon the commercial transaction that the instrument called a driver license denote to, versus you giving up one of these. Let me show you. If you watch my previous lesson I did yesterday or the day before, I actually expound upon that. This is what we have. When they pull out that driving license, all right, when they stop us and ask for identification, right, please, you said it right there on the driver license that the instrument that they ask you for is not for real identifying purposes. So how in the hell are you identifying? Okay, so that means that majority of the people are in that same position because it's already assumed we are being a legal fiction. All right, so you need something that shows the diversity of jurisdiction, which is based upon your affiliation with that body of politics. And 99% of the people who are called citizens don't have an interest or affiliation with the body of politics because the municipal law is the law of the nation. This is most of your encounters is on the municipal level. So if you pulling out that ID, then guess what? They saying you ain't a real person because it says on it not for real ID purposes. So when we give out an ID, this is what ours says. As you can see, New Jersey Revised Statute 61 right 61-28, right stated under the charge of Great Britain, safe from appeal, an act to incorporate trustees of religious society for property held in corporation place of. Section 30 and 6-2 were all statutory language that do. Hey, hey, I'm having class. Get out the window. Peanut. Hold on, my dog barks. Yeah. Okay, this is okay. I'm almost finished. Okay, as you can see, 16:1-4 gives us the power, okay, to do whatever we need to do in regards to the affairs and the internal affairs of our religious society. Okay? And on the back of it, it also shows you who we are. All right. Now we didn't just make this up. Why? Because we have lawfully incorporated with the authority to do what it is based upon our certificate of incorporation, which is nothing more than what we call our charter. Our charter of incorporation. Okay. Our charter of incorporation. So your question, Gavin, the different, yes, it's effective. Your rights can be protected because New Jersey and New York are actually one. Okay, prior to New Jersey, we called New York, it was called New Amsterdam, which was a part of New Netherlands. Okay, don't worry about it, Brother Thomas. All right, so we must understand what's going on, what's at stake. Okay, what's at stake. Any more questions? Did I answer your question, Gravity different? All right. Let's see. Let's look at our powers. Power. This is the power we have. Power, every religious society or congregation incorporated by the virtue of any law of the state shall have power too. Now, every religious society incorporated in the state is based upon the 501c3. Why? Because it's based upon civil or it's based upon some religious belief, which is a right to do so based upon the separation of church and state. Yeah, this is one you receive from us is your real ID. All right. This is how you identify based upon your oath of allegiance to the crown. Okay, because that's your new nationality. As based upon you proving your pedigree to the crown. So you have to prove who you are. Our ancestors put things in place to prove your protection. And even in our ancestors' history, foreigners were also protected under the crown, which is also possible as well, based upon your oath of allegiance by way of you not committing an act of abjuration. So yes, the IDs we give you is a form of identification based upon your nationality, going back to, as I said in that case law, dealing with your surname. Okay, what is your surname? Guaranteed different. Please show me your surname. Give me your surname. Let's look it up right now. Cunningham. Okay, let's see. This is the last question I'll take on the floor. I hear you, Pina. I'm coming, Boo Boo. Okay, here we go. Cunningham, history, family, question, coastal bond. Over, fork, over. Cunningham. It's Scottish and Ireland. Now, we must remember when you're going back to the King Edward the Peaceful, based upon his council, they all took allegiance to King Edward the Peaceful, all right, at his coronation. So you might have Scottish descendant and Ireland descendancy in you, but your obligation is to understand what part that your ancestors had based upon the ancestral origin of where they live and correct that. Okay? Correct that. You know what I'm saying? And live in harmony with the law of that which is the overlordship or the Lord Paramount. Because you can see as the origin of the name, which is sent down from those who were running or sitting in the seat of parliament, i.e., the King's Court or the King's Council, which was called Witten, they were not living up to the original contract. So you must understand that you have a part to play in lieu of your allegiance, all right, based upon your status. So it says the ancestral name of Cunningham comes from the ancient Scottish tribe known as Delridians. They live along the rugged west coast of Scotland and on the Hebrides. Islanders use the name to indicate persons who lived in Cunningham. So your name denotes the territory area that your ancestors come from. Okay. However, numerous branches of the Cunningham family spread all over Scotland. Two of the most prominent branches of Cunningham claim that Cunningham was Cornshield and Cunningham of Caprington, trace their ancestry back to the medieval era. So it's very important to understand that those who are associated with that name all have affiliation based upon their clanship. All right. But now that you understand the relationship that those clans have to a body of politics, is your obligation to make sure that your comprehension and your application of your inheritance based upon where your surname descend down from is uniform. Because we see that those kings of England, who were kingdoms of Scottish and Ireland, were uniform with the Kingdom of England, as we see in the Treaty of Union of 1707. Does that make sense to you? Uh, um, uh, my first name is Clifford. All right, Clifford Jefferson. Your father, Clifford Cunningham. So welcome, um, Mr. Sister Cunningham from the House of Cunningham, Countess Cunningham from the House of Cunningham. Welcome. We welcome you. All we ask you to do is do the knowledge on what's being said today. And when the doors open, make sure you comprehend when required to find out if you have a right to the inheritance of the vast estate that was left for you and your ancestors. Okay? By coming up and surrendering your authority based upon your oath allegiance to the Lord Paramount, the crown. There's no other way it could be done. Okay? Would you agree with that from the House of Cunningham? Would you agree with that? Okay, great. So with that, I really appreciate you for not only being here but asking questions. Understanding that we have to accept the truth with the falsehood, the right with the wrong, the wicked with the righteous. You know what I'm saying? Because we all have to elevate ourselves. We have to continue to move forward. So once again, these lessons are here for a reason. All right. And I need you to once again continue to go back and watch these lessons. You are responsible for those who bear the surname Cunningham. You are responsible now. All right, because it's better for you to not know this than to know this and not follow it. So when your ancestors welcome you home on the ancestral plane, they're going to ask you these same questions based upon your cellular signal, which you're receiving now, based upon your cellular lineage, which is happening on a genetic level. The reason why you're here today is because what's happening on you on a molecular level. Okay, so once again, I appreciate you. I'm glad you were here for the long haul. And once again, we all have to wake up sometime. Okay. So I appreciate you. Leave a response in the chat as well as the comment once this lesson is finished, as well as reach out to us any more concerns that you have in regard to uh, the interest in your birthright. Once again, to all those who are viewing, all those who will be viewing, and all those who want to view, uh, it's honorable to show uh, your liege to your king, friend, common soldiers by way of donations, and you can donate to the Third Temple English Church of England or to your king, $ Clifford Jefferson L. And I really appreciate you once again for being here. And once again, you're welcome, Gavin Cunningham from the House of Cunningham. I really appreciate you being here. I hope to see you here at the next lesson. Tune in with the website as well as visit the website, the Third Temple English Church of England, which is the formal website outside of YouTube, where you can get an insight, internal look at what it is that we do based upon our membership as well as our disclosure of our disclaimer. All right, and with that, thank you all for joining me, and I'm going to greet you as I always greet you, and that's in peace and love.